Please, Your Lordship.
Yes, please.
On behalf of V. Supreme, Additional Advocate General, she's indisposed and she's attending the principal seat. So some matters I'd like to mention on her behalf.
Yes.
Item 3
Item,
will be listed after 2 weeks. And item
Mr. So-and-so makes a mention on behalf of Mr. Ms. V. Sokre, the learned additional AG, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay, item 3.
Your Lordship,
Then-
similar prayer for item 4.
Just one by one. Item 4, same order. Then
6,
item 6, same order. Then
7,
7, same order.
and hearing item 22 and 23.
Hearing item 22 and 23, same order. Okay? 22 and 23, okay,
Obliged.
yes.
May I please, Lordship? Lordship, for item 7, Lordship, we have already served a notice to the respondent number 2, Lordship.
Item 7,
Yes, Lordship. And we have also filed an affidavit.
okay, item 7, just let it come as per the list. Item 7, we just like to see the file, okay?
Lordship.
Okay,
May I please, Your Lordship?
yes,
Your Lordship, I'd like to mention item number 10, Your Lordship. Your Lordship, I am appearing for respondent number 2 and 4, Your Lordship.
2 and 4.
Yes, Your Lordship. Your Lordship, if the matter can be posted after 2 weeks, Your Lordship.
What is the review matter?
Your Lordship, the petitioner is seeking for pensioner benefits, Your Lordship.
Review.
Yes, and really it is for the appeal order, Your Lordship, appeal dismissal, Your Lordship. Where it was denied for payment of, for regularization, Your Lordship.
And review is in regard to whose order?
This honorable appellate court order, Your Lordship.
Okay. Mr. Solo, you are for?
2 and 4, Your Lordship. Respondent 2 and 4.
Mr. M. Solo, the learned counsel for the respondent number 2 and 4, seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Mr. Ma, you are here? Okay, after 2 weeks.
Congratulations.
Yes.
Yes, Your Lordship.
Yes.
I'd like to mention item number 13 to 21. My senior is indisposed.
And who is your senior?
Mr. L. Nikashe Santa,
13 to?
21. I believe this matter may be listed after 2 weeks.
Okay. Mr. So-and-so submits that Mr. L. Likase, the counsel for the respondent, correct? Counsel for the respondent is indisposed and therefore seeks adjournment of the case after
2 weeks.
2 weeks. Prayer is allowed, listed accordingly. Okay.
Much obliged.
For admission, item number 1.
Yes,
Mr. Lordship,
yes,
I
yes.
found my Pamela this morning. I mean, we don't, oh, the measure may be fixed on 1st November, for taking the consent of the opposite party.
1st November for what?
To file a reply.
This is appeal.
Appeal and section 21 of NI. Again, it's the granting paid to the respondent.
Will it be necessary for you to file a counter
Yes, ma'am.
in appeal?
Yes, ma'am. I have received instruction to seek more time in order to file counter affidavit.
Mr. So-and-so, learned counsel submits that he has filed his power on behalf of,
Esther,
on behalf of,
on behalf of respondent,
on behalf of sole respondent,
Sole respondent.
on behalf of the sole respondent, only today, and therefore submits that the matter may be listed after 2 weeks so as to enable the respondent to file affidavit if so advised. Prayer is allowed, listed after 2 weeks.
My lordship, can you fix on 1st November, my lordship? I have other
Your good name, Mr.
Satyanand,
So-and-so,
senior PPN.
senior PPNIA, appears for the appellant. Ito listed on, let's see, kiman time this listed on? Huh? When do you want?
1st of November, my lordship.
Listed on 1/11, what is it?
Wednesday, 11. 1st of November.
Okay, okay, no. Listed on 1/11/2022, 23, okay.
For admission, item number 2.
I please your lordship.
Yes, please.
Lordship, here the parties have a consensus prayer. If your lordship may be gracious enough to list this matter after 2 weeks.
What is this about?
Hold on. Regarding the citizens bylaw,
Regarding?
census of 2011 bylaw.
2011 census still pending?
Yes, my lord.
What are you challenging?
My lord, I'm challenging the Honorable Court Single Judge order dated 4/7 of 2016 bylaw, 17 bylaw.
And what was the order?
Text 150 my lord.
No, just give us the gist.
All the contents, my lord.
Just give us the gist. Why have you challenged?
My lord, the Honorable Single Bench has not considering that with regard to Musa village, that one is staying as a big spot.
Stay?
Yes.
Ah.
And to Junlang village also, that case also stayed and a big spot, my lord.
Is it still pending in the Honorable Apex Court?
Yes, my lord, I presume that that one is pending, my lord.
Don't presume. Give us a definite answer.
My lord, this apex court it is decided that the election petition is disposed, and that regarding the citizens, it is leave to the authority concerned, my lord. That's by the decision of Supreme Court, my lord.
So what has the authority decided in the other cases?
My lord, it is because commission is not taking that the census authority has not conducted the census. Actually, and everything else is used to take care of the count census. my lord.
Kindly come prepared. We will we will dispose on the next date. Kindly come prepared. Don't come casually, Mr. Mully. On the prayer of the learned counsel for the parties, listed after 2 weeks. Stop. The parties shall make an endeavor to dispose the case on the next date fixed. Kindly come prepared.
My lord.
For admission, item number 5.
Yes, Mr. Vijamomi.
And for respondent number 3, 4, and 5.
What is the matter about?
Description of the commission. The commission in the state of Nagaland. Here is the
What is the last order passed by this court?
Your Lordship,
Yes, Mr.
CGC.
Yamawati, you have received the necessary instructions.
I sent the editor for vetting.
Are you sure?
Yes, 100%.
What about the state?
we have filed that. We have filed out.
The other parties, they have all filed.
Okay.
Your Lordship, I'll also be filing affidavit in reply to the affidavit in opposition filed by respondent number 3, 4, and 5, Your Lordship.
3, 4, and 5.
Yes, Your Lordship.
Mr. Yamawati, the learned CGC submits that the affidavit in opposition on behalf of the respondent number 1 has been sent for waiting, and therefore 6 for 2 weeks,
3 weeks, pleasure.
therefore 6 for 3 weeks' time to file the affidavit in opposition. MS so-and-so, the learned counsel for the petitioner, also submits that she may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 3, 4, and 5. Stop. Listed again after 3 weeks.
Acknowledge, Your Lordship.
For admission, item number 7.
Yes, what,
Please, Your Lordship.
yes,
Lordship here, as per my affidavit dated 19/9/2023, Lordship. Lordship, we have already served a copy to respondent number 2, and also we have filed an affidavit stating,
so what was the order complied? Order dated?
order date 19/9/2023.
19/9?
2023.
19/9. There is no 19/9.
It's bit 13.
13, correct, ma'am? is allowed to file affidavit and can also take steps for service of notice of. You have filed the affidavit in reply,
Lordship.
correct?
Yes, Lordship.
And you were also directed to take steps by dusty process.
Lordship, Lordship.
You have actually taken steps
Yes, Lordship.
and you have filed affidavit.
Lordship.
What is that affidavit?
Lordship is dated 19/9/2023.
19/9, that's 29/20, an affidavit of return.
An affidavit on behalf of the petitioner producing the copy of form number 2A for return of service upon respondent number 2.
Respondent number 2.
Lordship.
And who is respondent number 2?
Here the respondent number 2 is the
Nagaland
Public Service Commission.
Nagaland Public Service Commission. Mr. CT, you were actually the senior standing counsel for this Nagaland Public Service Commission?
No, Lordship. From case to case, we used to engage.
Okay.
In fact, in one or two cases, I have also filed where NPC is also a party where there is no conflict of interest.
Okay, I thought you were dozing, so you were not aware when this case was called.
I'm not.
Okay. So it's a case-to-case basis.
Lordship.
Okay, thank you so much. Okay. Whether NPSC will be a necessary party here? What is your grievance against the NPSC?
Lordship, here we are challenging the advertisement that has been issued by the NPSC, Lordship.
Advertisement issued
Yes,
by
Lordship. To fill up the post of assistant headmaster under Education Department, Lordship.
Where is your affidavit? Let us see. Whether the advertisement issued by the NPSC has been stayed.
Lordship, it's dated 21.
Whether actually the advertisement has been stayed.
Yes, Lordship.
It has been stayed.
Lordship.
You have interim protection.
Lordship.
Okay. Mr. Your good name, please.
V. Kozar, Lordship.
So and so, the learned counsel for the petitioner. Stop. By the order dated 13/9/2023, this court had allowed the petitioner to take steps for service of notice upon the respondent number 2 by dusty process within a period of 3 days. Stop. The petitioner has complied with the order and has filed the affidavit 29/2023 to that effect. Notice upon the respondent number 2 is therefore deemed served. Then what happened? Deemed served
Lordship.
upon respondent number
Yes,
2.
Lordship.
Mr. So-and-so makes a mention on behalf of MS V. Socrates, the learned additional AG, and seeks adjournment of the case for
2 weeks.
2 weeks. Prayer is allowed, listed accordingly.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next returnable date. Okay?
Highly obliged.
Yes.
For orders, item number 8.
Yes,
Please, Your Lordship.
yes, please.
Lordship, on previous occasion, the service of notice upon respondent 5 was submitted.
5.
Yes. Lordship.
Respondent refused. Notice issued upon respondent has been returned unserved with remark refused. What to do now? That fellow is refusing to accept. Respondent number 5, correct? Who is respondent 5?
Respondent number 5 is NPTC,
NPTC is?
National Blood Transfusion Council.
So what happens, Mr. Muse, if there is no acceptance?
Those in fact, they are the main respondent. They are supposed to give us the clearance for setting up the blood transfusion. The recommended steps by publishing the National Daily Council, because they are the main respondent. Because to set up a blood for products very logic, we need the permission of the council. And we have already placed it to the council for the permission.
Okay. Yes, I think
Lordship, kindly allow me to serve through substituted notice then.
paper publication.
Yes, Your Lordship.
In which newspapers? In which newspapers? It should be a national newspaper. At least 2 national newspapers. You get the information and come. Okay?
Yes, Lordship.
We'll just fix it next week. You get necessary information and come. Okay?
Lordship.
Okay? We are not recording, but you get information and come. The
Lordship.
papers and all this, okay? Listed again on. Or 11, yes. Listed again on 11/9/2023. Okay?
11:10.
11/10. 11/10, I'm sorry. Okay.
Much obliged, Lordship.
For hearing, item number 9.
Yes, Mr. Hiralo and Mr. Siti, what is the matter about?
Your Lordship, the matter is about the non-implementation of clause, section 15, rule 15, clause 2 of the Nagaland Civil Supplies Service Rules. From the inception of the service rule 2002, the clause, rule 15, clause 2 has not been followed, which provides quota and fixation of seniority on rotational basis. That has never been followed. All along, the seniority has been fixed on the basis of length of service and the point of their entry into service or date of promotion.
So the service rule has never been followed.
That has never been followed. That is the only point in this read appeal.
So whether it should be treated as redundant or?
Yes, because that quota water has already collapsed. So if it collapsed because of not implementation of that rule, then the rule collapsed, and then subsequently that rule cannot be followed, that rule cannot be implemented. And the result would be that the seniority has to be fixed on the basis of land of continuation of service.
Yes, what is, let us just hear the gist.
To make it very short and brief, Rule 15 clause 2 says that indices seniority of direct recruits and promotees shall be fixed on the basis of rotation of quotas, making the promotees that when the recruitment is made in the same year, making the direct recruit, promotee as senior. So in short, since Rule 15 clause 2 has not been followed in the past, that should not be followed even now. That is the
So what you are submitting is that on your side also you said that the rule is redundant.
No, rule is to be followed. In fact, we have also filed a writ petition. They have filed one, we have filed one.
Okay.
Now, both the writ petitions have been dismissed because
Yours also dismissed,
Yes.
his also dismissed.
yes, my
No, you must have been
Just wait.
in my
Yes,
petition was the provisions of Rule 15 clause 2 says that year of recruitment. So year of recruitment means when the recruitment starts. So the ratio, taking the ratio laid down in the NR Parma's case, that seniority will be counted from the date of sending the requisition. That was overall in Mikhatendra's case in 2020. So in view of that, my case has been dismissed. But when the writ petition was filed, Mikhatendra case was not there. So taking refuge in the NR Parma's case, I filed the case. But by the time the writ petition was heard, Mikhatendra's case was already there from Manipur. So the ratio which I was maintaining has been overall in Mikhatendra's case. So I have accepted the judgment and rule is to be followed. So far as the present appellant is concerned, their full contention is that since the rule has not been followed in the past, quota already lapsed, it should not be followed. But the learned single judge said that no, even if the rule is not followed in the past, the rule has been made to be followed. So it has to be followed and applied. And the seniority list which has been fixed in the year 2018 has been fixed strictly in accordance with Rule 15 clause 2.
Okay.
That is the rotation of the vacancies between the promotees and the direct recruits. When the recruitment is made in the same year, then it should be on the rotation basis, making the promotees, they are the promotees and the direct recruits first. So when there are 4 vacancies, promotees, direct, promotees, direct. So this imperial seniority list which they have challenged is prepared on the basis of strictly in accordance with Rule 15 clause 2.
That is alternatively.
Yes, alternatively, they are coming before this court, challenging the order of the learned single judge on the ground that no, earlier the rule has not been followed, it should not be followed. But the learned single judge has rejected on the ground that look, now that you are submitting this point, but when the writ petition was filed by you, this was not a point of contention. This was not a part of the pleadings in your petition, so I cannot accept that. That is one of the reasons given by the learned single judge. If your lordships go through the judgment, appeal judgment, paragraph 14 to 18. Clearly, the learned single judge has given all the reasoning. There is absolutely no ground to be re-examined again by this appellate court, because lordship, whatever the learned single judge has said is, since rule has been framed in accordance with law, that is to be given effect to, and that should be followed. The one that since it is not followed for a long time, it should not be followed. My question is, Lordships, can it be the ground that since rule has not been followed in the past, even now also it should not be followed? That may not be a sound reasoning and court law.
Yes, Mr. Hiralu, because unless the rules are,
No, the rule
unless
is
the
clear.
rules are repealed, replaced or amended.
No, that is totally a different question.
Okay.
Because it is not that the rule should not be followed. The point is, the rule is there, which according to the Supreme Court also it is valid. Fixation of quota, providing quota from two sources of recruitment, and fixation of seniority on rotational basis. There is nothing illegal about it. It is right. But if that rule has not been followed for a considerable period of time illegally, then the consequence comes in. Consequence is that principle, that rule cannot be applied. And then the general rule of fixation of seniority has to be followed. That is, in several cases, the Supreme Court has laid that down. And that is on the basis of that we have filed this petition. That is the supporting case of our case. It is not that the rule is illegal. The rule is valid, constitutionally valid, but no implementation. The consequence is now after that rule collapse. Then if we have to go back to that one, then there will be discrimination and inequality between the two sources of the employees.
When actually you are making a submission that the rule is absolutely valid, where is
It
the
is
question?
valid.
Where is the question of the rule collapsing?
Now, because that has not been followed for a considerable period of time, if that has not been followed, the Supreme Court says now that cannot be implemented. Because the question comes subsequent to the collapse of the rule and implementation thereof. Because in the cited cases which we have relied before the learned single judge, now all those has been highlighted by His Lordship. But no reason has been given why the law laid down by the Appellate Court cannot be followed in this. If it is distinguished, that is a different question. But that has not been distinguished even. And then that has been swept away. Then what is the benefit of a law laid down by the Supreme Court? We are bound by that one. With all due respect, we have to bound by that one. So because our main contention is since prior to 2002 service rules, it was also there. And in that also, two sources of recruitment, promoting and direct recruits. Quota and rota is there. But that has not been followed. Now the amendment came up in 2002. Even after 2002 amendment of the rules, quota rota rule has never been followed, which is provided in Rule 15 Clause 2. So if that has not been followed at all, the consequence, what is the consequence? Now inequality comes in, discrimination comes in, because it violates Article 14 and 16 of the Constitution. That is what the Supreme Court says. And on the face of it, now besides the law laid down by the Supreme Court, the learned single judge has dismissed the petition on the ground that it is not that a rule cannot be followed. And then one of the reasons is that one. The other reason given by the learned single judge is the rule has not been challenged. Why we should challenge the rule when it is constitutionally valid? And in all the cited cases, which is also reflected in this order, in Pin judgment, no party has challenged those specific rules.
Lordships, here is a situation where recruitment has to be made in the same calendar year, direct as well as promoted.
Because if you are
In
to
some
hear-
cases, in 1 year, only 2 recruitment, one is promoted, one direct recruit. Promotees were given, that shows that role has been followed. But for the first time, this situation occurred. Fixing seniority between
Yes.
direct
For the first
recruit and the promotees. So the department, by applying the rule, it was followed.
For the first time,
That since rule has
2007.
not been followed, it should not be followed.
Since when it was not followed, as per you? Since when it was not followed?
From the beginning.
From the beginning.
From the beginning.
When was the rule framed? Which year?
First was 1977. That time also quota rota was there between direct recruits and promotees. Then amendment was made in 2002. Same principle comes in 50-50, promotee 50, direct recruits 50, and rotational basis. That has not been followed. Now only in 2017, the department came up with this idea. Because
with what idea?
The idea of following this rule 2 plus rule 15 plus 2.
That is
Rotation fixation of yes. Now what happened was that in 2017, prior to that, the respondents, who are the direct recruitees, submitted representation claiming that their seniority should be counted from the date of the occurrence of vacancy. Now, accordingly, at one point of time, that was allowed. Then again, subsequently, that was taken out. And on the representation, the principle of quota rota has been followed in 2017 for the first time.
Okay.
Now, in respect of others also, other categories, other cadres, like above and below, the superintendent, senior inspectors of supplies. Below that also there is quota rota rule. Above that also it is there. But even in those cases, this has never been followed.
Not even once.
Not even once. So, in order to show that this rule has not been followed at all, now we have to go to the backgrounds of the case. So, for that, I need time to go to all those facts. Because we have to start from the date of appointment, how we were promotees. So the appellants of...
You are promotees.
We are promotees.
And Mr. City, you are direct.
Yes. So that is the conflict. So we have to show that the rule 15 plus 2 has not been followed, and we can show only on the basis of the seniorities. And so we have to put and the facts of the case, and whether the similar quota rule has been applied in other cadres also. We cannot apply only one instance. Equality has to be there.
Thought chiefs, I would just like to make a submission that may be a sort of a food for thought. To err is human. Human commits mistakes, illegal,ities at times is being committed in the process of implementing different orders. Here is a situation that, rightly or wrongly, intentionally or maybe unintentionally, it so happened that for a long time, role has not been followed. In other words, mistakes have been committed in the past, and very lately, such mistakes were detected. Technical principle in such a situation is that when a mistake is committed, then it has to be corrected. And if anybody seeks some relief, basing on the past instances which was not permissible in the IAP law, which the law do not permit. And if somebody acts on the ground that, look, in the past, this was followed, although it is illegal, since it has been followed, the same principle should also be applied even in my case. Whether such
Mr. City, just for some clarification. What was followed in the past?
in the past, the rules were followed. But there were situations where there was no occasion to apply rota quota.
That is Rule 15.
Yes. This is the first time the situation occurred to apply rota quota.
No, why actually the situation did not arise to apply rota quota?
Let me submit one aspect of it.
Yes, please.
If the rule was not followed in respect of others, earlier, I was not there. If they have not demanded for their right, can that deny me now?
You are a new entrant.
Yes, I'm aware of the law, so I'm insisting the government to follow the rules. If somebody have failed not to insist his right, that is not my responsibility and that is not my lookout. Somebody may have accepted, even if the law is not followed, he may have accepted, but I will not accept. I will go as per law. And since there is a serious law, it has to be followed. And if it is not followed in the past, I cannot see that, oh, in the past it was not followed, in my case, let me accept. No, I will not allow that. Therefore, in the light of the rules, I have to assert my right, I have to ask my right. And that has been given by applying the law. Now,
No, yes, that's why I'm
if
saying.
somebody has not
In the past.
Yes. In the past.
What was the wrong committed?
Yes.
That is why I'm asking you. In the past, what was the wrong committed? In the past.
That is the case.
No. You were also in it. So can you just kindly elaborate that? In the past.
In the past.
Why is the petitioner appellant aggrieved about the past?
In the past, most of the cases were promotees.
Okay.
Therefore, promotees
That
were
means
given
quota has not been
permission
followed also.
so there was no occasion to apply the rule. But we are the direct recruits. And we have to go by the rules. Recruitment was done in accordance with the rules. And the seniority has to be fixed in accordance with the rules. Otherwise, what is the point of framing the rules if it is not going to be followed? And the level civil judge has correctly held that yes, rule is to be followed. As simple as that, Lordships. And if a mistake has been committed in the past, it is the duty of this honorable court to correct the mistakes. And nobody can claim negative equality that in the past it was not followed, so in my case also it should not be followed. That cannot be. Equality is a procedural concept. Lordships are well aware about this. So, Lordship, there is no case in the present appeal.
The principle of negative equity cannot be applied here. Because now it is the duty of the department to be aware of their own rules. Knowingly they have not applied it. That is not human error. That is not human error. That is intentional. They have never followed that one. And at a later stage.
So you still want the promotees to have that advantage of promotion?
No. Whether it is promotees or directors, it has to be, seniority has to be fixed on the basis of their joining the service. That is the general principle of fixation of seniority.
On the basis of joining the service.
Joining of service or joining of the post on promotion.
Rule 15, does Rule 15 speaks about quota rota in a calendar year?
In the calendar year. And so in the past, even this quota has never been followed. there are more promotees than the direct recruits in a year. Sometimes there are two. Sometimes there are promotees for no direct recruits in a year. Sometimes two. And in the year 2012, we were promoted and then they were appointed through direct recruits. And can I go in detail for him?
Let us hear it properly next week.
Your Lordship.
Okay.
Yes.
And kindly give us the written gist also.
Yes.
The facts, because
That will be
actually
better.
we don't want to get confused with the facts.
Yes.
But to make it clear, Lordship, recruitments, as Lordship has correctly pointed out, that Ruta Kuta, that is to be maintained when the recruitment is made in one calendar year.
Yes.
Earlier, there may be 5 recruitments, all happens to be promotees. 3 direct recruits happens to be directs only in different years. So there was no recruitment in one calendar year among the direct and the promotees. It happened in our case. There may be some stray cases, we are not bothered. So this is a case where for the first time the situation.
So Mr. Irano, just correct me. Just correct me.
Yes.
You are promotees.
Yes.
So even for the promotion which did not take place in a particular year where the where the directs were not there, you are seeking quota. You are seeking your right even for that year.
No. Because we were promoted only in 2012.
2012.
Yes.
And
Our promoted,
Mr. Seti, your respondent was appointed when?
2012.
2012.
Yes.
So 2012, as per the Rule 15, then they have to get the first preference of promotion.
Yes.
1-1.
Yes.
1-1.
That is
Yes.
what the seniority, individual seniority list has done, which directly.
Okay.
Because-
One the promotees, next the direct, then the
Yes.
Yes.
promotees.
In other words, Rule 15 clause 2 has been followed for that year.
Only in this case. That is the difference, Your Lordship.
Because this was the first time the situation arose to apply the rules.
Oh.
Prior to also it was
In the past,
It is not the
in one
different
calendar
time.
year, 4 promotees. There was no direct
direct.
recruitment. In one year, particular year, there were direct recruits. There was no promotees in the same calendar year. Therefore, the question of application of Rule 15 clause 2 doesn't arise.
Your Lordship, in order to dispute that one,
For that purpose, it has been fair.
we have to go to the past seniority list, how that has been done. So the past seniority, especially from.
But we will be taking up only post 2017.
No, now.
Post 2017. After the new rules came into force.
No. That, from 2002. Even before the rules, whatever we have to see, whether the rule has been followed. After 2002.
That is a closed chapter. As per me, that is a closed chapter. The old rules. Whatever happened under the old rules, that is a closed chapter.
No.
We now have to see Rule 2017.
Old rules 2002, Your Lordship.
2017.
2002.
Oh, new rules, 2002.
Yes, amended rules.
Oh, that is
before that.
That is followed. That is being followed even as of date.
No.
2002.
2002. That has never been followed.
No. 2002 is in force as of date.
Yes.
It has not been amended. It has not been done away with.
No.
2002.
That is the amended one.
Okay.
2002 is the.
I thought
amended
17.
rules. Yes.
Okay. So kindly give us the gist of your submission also.
Your Lordship.
Let us see to what extent we can go next week. Yes, Mr. Siti.
Yes.
You are actually smiling as if you have a very good submission.
Whatever I have in my mind, I have already expressed. I'm not hiding anything.
Good.
I'm not also hiding, but I'm not confident. That's the difference.
That your lordship,
Yeah.
I'm representing the state here.
Okay.
It's a long, very long pending case.
Long pending case, this is,
2022.
The lordship will fight.
Just managed
Because
2022.
of this appeal being pending,
Yes.
we are confronted with the promotion. Promotion has been delayed. Lordship will fight.
whether the learned single bench decision has been stayed. Whether it has been stayed,
Status quo is that?
status quo.
Yes.
Oh, status quo.
That's why we have that problem. So now, lordship, this is about the inspectors only. Inspectors who were directly recruited through university and those who were promoted. This is that only. Roti that my learned senior friend is saying, sometimes because we are confronting this is the first kind of a case for Roti. Because before, inspectors were directly appointed by the state. Now, in 2002 only, NBC as the president and rejoined these inspectors. 2012 only. So that is the thing which your lordship must keep in mind.
2002 or 2012?
2002. The rule is 2002.
But the situation to apply Rule 15 clause 2 has arisen in 2012, where there were promotees and their recruits in the same country.
Okay, 2012 actually like this,
Situation allows to apply Rule 15 too.
since there were promotees as well as direct recruits.
Okay, in the same country.
And before 2012, there was only promotees.
There may be cases where only there were direct recruits or promotees. But there was no occasion to
apply that quota rota.
Yes, to apply the rule. Treatment in the same country. And nobody will approach this honorable court that in the past rule has not been followed, so even now also the rule should not be followed. I believe the petitioner will not come with that pleading.
Your Lordship, that is a wrong pleading. It is not my pleading.
It is not.
That it should not be followed. My plea is that since that has not been followed, now if that is followed, then discrimination is there and it violates the equality clause of Article.
Mr. Yalo, just explain what is the discrimination? What is the discrimination?
Discrimination means supposing if now we were promoted and appointed in 2012, we were promoted prior to their appointment, about 6 months. Now, after several years, in 2017, if we are to apply the quota rota rule, then normally, as per the general principles of seniority, we are senior because our promotion and joining is prior to the direct recruits. So, after collapsing of the quota rules, if that is applied, now one will come after us, and another, and the other. Then we will become junior to them. That is where discrimination comes in, and the Supreme Court says that.
No, what do you mean to say is that by a few months, the promotees are senior. Let's take, for example, 2012.
Yes.
By a few months, you are senior.
Yes.
Okay.
Yes.
So if in the year 2017, right, this quota rota is applied.
Yes.
2017,
Yes.
quota rota is applied.
Yes.
Then actually the bunch of the promotees, some of them will become juniors to the direct recruits.
Yes.
That is exactly your case.
Yes.
That is exactly as per Rule 15 clause 2.
Now, the question is what the Supreme Court says on that. That is,
But whether in a calendar year, all these promotees and direct recruits
whether it is
were
in a
appointed
calendar year or not,
in a calendar year.
Yes, 2012.
it is 2012. No dispute about
They
it.
are claiming that they are senior by a few months.
The point is, if the quota rule has collapsed, then what is the consequence? That is the point.
Well, we'll see whether it has collapsed or not, but if you're all
Yes.
like the promotees and the appointees of the year 2012, then in that case, I think that quota rota has to be applied. If you are all 2012. If you are all 2012 batch, promotees and the direct recruits, then one has to be after the other.
Yes.
The other one has to be after the other.
Rotation wise, it will be like that. We are not disputing about it.
Then where?
There is no dispute about it. If we follow the quota and rotational seniority, then that will be the principle. No doubt about it.
And
The question is, Your Lordships, the question is, if the rule has not been followed for a long period of time, what is the consequence? There comes it.
No. 2012. 2000, you are
2012 or no, that is not my point. That is not my case also. But my case is, now this rule has collapsed. Quota rule has collapsed. So it cannot be applied at this time. It can be implemented at this stage. That is my case. Otherwise, fixation of seniority on the basis of quota, we are not disputing about that. That principle is correct. When appointments are made from two sources in a calendar year, those things are not disputed. The principle is correct.
That's why I'm asking you what exactly is your case.
My case is that.
Just in a gist.
My case.
Let me also get myself
My case is, since this quota rule has never been followed, it has never been followed, it has already collapsed, and therefore that cannot be implemented at this stage. That is my case.
Just because somebody has invented a new theory, and we are made to be quoted by bringing such a theory.
So you're saying it's never to be implemented. At what stage is it going to be implemented? It's not to be implemented.
From the inception of the service rules, it is to be implemented. Otherwise, what is the point of having a rule? We cannot choose after framing a rule that
Mr. Iralo,
follow this one.
Government-
some point of time we will say no.
government has framed the rules. Government has framed the rules.
Yes.
After framing of the rules, if the government has not implemented the rules for a year or two, and thereafter the government says, no, we will go by the rules. What is wrong in that?
The question, it will depend on the facts of that case.
Not necessarily.
Why a particular rule has not been followed. Now, if in some cases, it may be there, but it may not be that that rule has collapsed, like the present case. Facts will be different. And quota is there, 50-50. 50 promoters, 50 directors. That also has never been followed.
It seems that this hearing may take some time. So
Yes.
we do not want to leave anything part-heard because this is our last day.
Yes.
So if we leave it part-heard, then it may be after 4 or 5 months, 6 months. So next week, we take a chance.
Yes.
Next week. Listed again on. Eleven ten. 1993. And about the learned senior councils, if you can kindly submit the gist.
Yes.
Just the gist. And Mr. Moore also, on the government side, just the gist. So
Should
that,
we submit before agreement or
It'll be very good, because as you argue, we can just scroll through your gist.
Yes,
It'll be very good very helpful for us.
yes.
Okay?
Yes.
Okay.
Lordship. For hearing, item number 11.
This, Mr. Ncham, what is this?
This pertains to the allegation of the petitioner that we are not adopting the National Hepatitis Program. Or should we have filed an affidavit where we have stated that the program is fully enforced now? My affidavit.
And madam, what do you say on the affidavit file?
Lordship, yes, I have to clarify on that because when this petition was initially moved, this is in fact the similar issue was raised in the year 2011, and there's a judgment passed by the Supreme Court also, where this petition is specifically confined to hepatitis C treatment and to make it free. Because most of the patients who are suffering are from a very poor community, and though it's curable, but with the treatment, timely treatment, but then since they cannot afford it, that's why their rights are denied. So that's why initially.
Madam, just one clarification.
Yes.
Whether it is the government policy to provide free treatment?
Yes, it is, your lordships. Now, in the year 2018, when this was initially filed, because 2011 judgment was not implemented. So during that time, the program was not rolled out. But during the pendency of this case, central government has also initiated a new program called National Viral Hepatitis Control Program.
Okay.
And there it has made hepatitis C, it has not only covered hepatitis C, but even hepatitis B to be given free of cost.
Okay.
So accordingly, your lordship, yes, it is, I should admit that the central state government has also done some justice to the implementation of this program. And then accordingly, a medical treatment center has been set up in Naga Hospital Authority, Kohima.
Okay.
Then also treatment centers in Dimapur, Mokokchung, Changsang, Zeniboto, Mon, Magnan, Kiferi.
For hepatitis?
Yes, for both B and C.
And are you providing free?
Yes.
So,
medicine and
yes, as far as medicine and testing of hepatitis C is concerned, but I still have some grievances which is reasonable and can be fulfilled because the program says so. The program says that the free screening, diagnosis, treatment, and counseling. So, in my affidavit reply to the affidavit filed by the state government, I have also enclosed a copy of the National Viral Hepatitis Control Program, and where the union has come, the Ministry of Health and Family Welfare has given a operational guideline, which clearly specifies and talks about how this program has to be rolled out. So, your lordships, yes, few districts have treatment center and model treatment centers there initiating, but there are some shortfalls, your lordship, in the sense that whenever a patient comes, or whenever they are tested, they with hepatitis C positive, now they come to the treatment centers. So what happens was that normally, sometimes based on the requirement, the medical doctors prescribes that there's some baseline investigation is done. So sometimes they need to undergo complete blood count tests, then liver function test, kidney function test, and then there are ultrasound, also fibroscan, and sometimes beam time, and then ECG. So now, what is happening in the state of Nagaland is these are supposed to be included in the package, but the patients are making out-of-pocket expenses. And another grievance, that is another shortfall that is happening in the center is that some treatment center does not have a true net to, because once infected persons they start treatment, they have to be undergo a review. They come for review treatment. During that, they have to undergo viral load test. The viral load test is done to see whether they're responding to the treatment. Then only then again the doctors will prescribe medicine. And if in case, because it's just curable, in case if there's a positive outcome, then their treatment can be stopped. So during that time, let's say when they come for treatment, those treatment centers which does not have a machine to test. Usually in Nagaland they're using TrueNet. So some treatment center does not have that. So they offer testing kit. So sometimes there is also shortage of cartridges because they use cartridge for one person for two tests. So that is only one time use. So there are cases of shortfalls. And the stockout issues are there. So this disrupts the treatment. And also, Your Lordship, they're using four medicine, three medicine. One is sofosbuvir, then in combination with daclofenavir, and also sofosbuvir can also be used in combination with Verpastazvir. So there's only the three medicines that are used for treatment at this juncture. So there are also cases of shortages. That is why the patients are also affected, treatment is effective. So yes, as far as free treatment rollout is concerned, the program is out now. Then the state has brought out, some district is yet to have. The guidelines says that every district should have one treatment centers. So Lordship, while closing this case, if this Lordship would be so kind to give some direction that there should not be stockouts of medicine and also testing kits. And also, if there seems the baseline investigation tests that are recommended by the doctor as per the requirement, if these are also made free of cost.
Well, why don't you give your points in writing?
Lordship, I can do that, Lordship.
So that we can actually pass some orders on the basis of that, we can close the case.
Yes, Lordship, if I can do it today also, Lordship, by evening.
Because Lordship, for me, in my afternoon, I have explained about the program, the National Virus Program, Control Program. How it was launched in the state in 2018, we have adopted in 2018, and it's in full swing, and we have set up treatment centers. We have research at NHK, we have BSL Lab 3. We are doing research here, Lordship. All the treatment, all the samples are collected and screening is done there in the NHK, Lordship. Besides that, Lordship, one of the most challenging part of the state in implementing the program is the government of India has centralized the procurement and supplies.
What?
Medicines and the testing kits. We are not giving the money. They have a centralized supply chain, Lordship. They are supposed to give us in cash, not in cash, but in kind, the medicines and the testing kits. So these are the challenges, Lordship. We don't get the medicines in time for reasons that's no Lordship. In time where we need it. I've said it in my paragraph.
Whether the central government has filed affidavit? You filed affidavit?
Since the procurement is all centralized, Lordship, we don't have a free hand. I do agree with the submission of the University Commissioner as far as the non-availability of medicine to on the spot.
I have not received a copy of the government certificate.
I'm sorry, Lordship, I've already submitted the copy, but like the copy is not with here, Lordship. But as far as the program is concerned, Lordship, the program is centralized. We get all in kind, the medicines, the testing kits, Lordship. And as far as the program is concerned, Lordship, we have a mobile treatment center at NHK, the hospital authority, Lordship, where every samples are collected and then testing is done there, Lordship. And we have set up the treatment center because Council for the Commissioner has already stated in 10 districts, Lordship, where free treatment is given to any patient who comes, Lordship. And also very interestingly, Lordship, the Petitioners Association, they are known as the Art Foundation, Access to Light and Knowledge. They have even conducted a seminar, awareness seminar in the Tech District at Fitzroy, in collaboration with the art department.
Good.
Lordship, I sought for the information, but like since I don't want to bring that on record, Lordship, but their association has conducted a seminar with our department in collaboration with the department, and we are spreading awareness, and which I feel the Council for the Petition also will not deny. One instance I've just mentioned, they are doing an awareness program throughout the state, sensitizing the people about the awareness of hepatitis C, A, B, C, Lordship. And as far as the role of the state is concerned, Lordship, I have specifically mentioned in paragraph page 9 how it was launched in the state of Nagaland, how many testing we have done till date.
Paragraph 9 of your affidavit?
Yes, that page 9 of my affidavit.
Page
9 of the state response.
4 and 5?
Yes, Lordship. If your Lordship can come to page 9.
The para B?
Yeah, B. National Viral Hepatitis Control Program in the state of Nagaland. As per overall review of this activities of the state. Lordship, it was launched in the state in 2018, Lordship. State Reference Laboratory set up at the Nagaland Hospital Authority, NHK. Model Treatment Center, there is MTC at NHK, as per the requirement in the guidelines, Lordship, as per the program. Treatment centers at Dimapur, Moultrie, Pingsang, Zolipur, Mon, Longland, Free Pack, and Parent. Viral load testing kit made available at MTC and all.
What is MTC? MTC?
Model Treatment Center.
And all TCs?
Treatment centers, yes. So we have all testing kits, Lordship. And it's machine, Lordship. We get spoiled, Lordship. So we have to ask for replacement. And this is the reason why the Learning Council for the Petition has stated like there are no testing kits available in some of the centers, treatment centers, because the machine gets spoiled also. So we have to replace it. Now, as far as the state profile is concerned, Lordship, from 2019 to December 2021, we have done testing. This is the data we have collected, Lordship, from all the districts where we have our treatment centers, Lordship. Total screen for hepatitis B, 37,526, Lordship. Total seropositive hepatitis B, 346. Total eligible for treatment for hepatitis B, 70. After screening, Lordship, the 70 people are eligible for treatment. Total treatment for hepatitis B, 62. That is from 2019 to 2021, Lordship. Likewise, the other issues, Lordship, hepatitis C. Now, Lordship, may I come to the long portion. These are targets for 2022 to 24. So we have big targets, Lordship.
What is HRGS? What is all this?
High risk group. High risk group. Lordship, it's not that we test each and every person, Lordship. After examining the patient, when there's a possibility of the patient having hepatitis B or C, Lordship, that's why we earmark them as high risk group. Now, Lordship, I can come to page 11. These are the challenges faced by the department in implementing the program. We are not denying the fact, Lordship. There have been lapses on the part of so, Lordship. But that is not intentional. Firstly, delay in supply chain. Lordship, as I've already stated, it's centralized, controlled by the government of India, with the Ministry of Health and Family Welfare, Lordship. They procure the medicines, the testing kits, and they give it to us.
What is NVHCP? What are all the short forms which we don't understand? NVHCP at the center.
National Viral Hepatitis Control
National
Program.
Viral Hepatitis Control Program.
How do we remember all these things?
Lordship, the terminology, Lordship,
Actually, you should use a full form so that it's easier.
yes,
exactly.
Lordship, yes. Lordship, in fact, I've explained in the paragraph, in page, starting from page 2, where the abbreviation are all there, Lordship. Page 2, paragraph 3. I've used the.
Page 2.
Yes. NVHCP is the National Viral Hepatitis Control Program. Then HBV is hepatitis B virus. HBC is hepatitis C virus. And HIV is hepatitis A virus. I've used the terminology at paragraph 3A.
Then NVHCP means?
National Viral Hepatitis Control Program.
During NVHCP is responsible.
All the terminologies, Lordship, I have explained here, Lordship. That's the reason why I've used the short term in the other paragraph.
Where para 3 you have explained?
Yes, Lordship. Paragraph 3A. All the terminologies are explained here, Lordship.
So, Mr. Yamarwati,
If Lordship additionally issued to the government,
you have a big responsibility to play because you are the source
yes, Lordship.
from where all the testing kits, medicines, everything is supplied because you are not financing, you are supplying.
Lordship, in fact, most of the programs, what is happening in the government of India is, Lordship, they have centralized the procurement. Even for the treatment of HIV and AIDS, we get in kind. There was a PIL filed by the Petitioner's Lordship for non-availability of HIV drugs. What we have explained that, same as this, Lordship, is all centralized. Government of India has centralized their own procurement. We get in kind. So there's delay in supply of medicines or testing kits in time. These are the challenges Lordship we are facing. But once we receive the Lordship, we are getting on the program.
Yes, ma'am.
Because
I think
then we are also a direction was given to the government of India.
I think whatever the state is getting from the center, I think that has been distributed. That has been, I think, given to the people. Now, unless the center gives the assistance to the states,
Lordship.
what happens?
Lordship, that's why if union can be directed to so that the supply does not get interrupted. Then
Interruption of the program. If government of India supply us, Lordship will do it. We have the manpower, Lordship. We have our treatment centers. The only thing required is the testing kits and the medicines, Lordship. Once they give us, Lordship, we will implement it. In fact, we are implementing, Lordship. It's not that we are not doing it. Lordship, the target that we have given is 2024, Lordship. 2024, Lordship.
To file an affidavit on the affidavit filed by the state.
Lordship, as far as the supply of medicine testing kit is concerned, direction will be issued against central government. But as far as matters related to baseline investigation, that is recommendation for other tests such as liver function test, kidney function test, and others, which is given as per recommendation by the government or by the doctor that is treating the patient. If this is the lookout of the state governments, they already have their equipments in place, so this can be covered in the program because this is part of the treatment package. So, Lordship.
Mr. Yamawati, I think you will first have to file.
My affidavit covers only this family methods.
Only?
only the funding patterns.
The funding,
The funds, yes.
they said they are not getting funds, they are getting only in kind.
No, but I did not know about this, the
He'll have to reply to that.
government.
So you reply, you file your affidavit.
That is why if I get a copy of the affidavit, then I will. Because, that's honest question, I have given the copy to you.
Because actually, the state government is saying that they are not getting any fund, only in kind. Whereas your stand is totally astray.
I'll get the instructions.
Heard MS Nito Koza, the learned counsel for the petitioner, and Mr. N. Nchum, N. Muzi, the learned counsel for the respondent number 4 and 5. And Mr. Gauhati, the learned CGC for the respondent number 6. Stop. The learned CGC submits that he has not received a copy of the affidavit in opposition. Only there is no affidavit in opposition.
Yes, I'll give you.
What about the reply? You have filed the reply, huh, ma'am?
Yes, Lordship, we have.
I have not received that also.
Okay, give him everything. Let us
Give him
see.
the copy, Lordship.
Let us see whether he will do his job. Yes, what is it? He has not received the copy of the affidavit in opposition filed by the respondent number 4 and 5, as well as the copy of the affidavit in reply filed by the petitioner to the affidavit in opposition filed by the state, filed by respondent number 4 and 5. Both the learned counsel for the petitioner as well as the learned counsel for the respondent number 4 and 5 shall furnish the copy of the affidavit in reply and the affidavit in opposition to the learned CGC. Ma'am, when? To the learned
By
CGC.
tomorrow, Lordship.
Within 2 days from
Lordship.
today. Stop. On receiving the affidavit from the learned counsel for the petitioner as well as the respondent number 4 and 5. The respondent number 6 shall file a comprehensive affidavit bringing out the stand of the respondent number 6, bringing out the stand of the central government on the stand taken by the state respondent as well as by the petitioner. The affidavit shall be filed within a period of shall file within a period of 4 weeks. Okay, ma'am? Okay.
Lordship.
Within a period of 4 weeks from today.
The submission of the government for the Union of India is that like we get the funding that is in 90-10 basis under the National Health Mission. Because this component comes under the National Health Mission. So they have not explained about the program, the whole mission as such. So that's why the affidavit is regarding the funding.
Okay, but there is no.
Yes, not in particular with this national priority.
Take Mr. Younger, you take note of that. Okay, you take note of particularly this scheme.
Because under the National Health Mission, we have different programs. So there are different components. So as far as our issue raised in the PI is concerned, they have not answered that. They have explained the whole.
Can you take note of that? Okay, in your affidavit.
We get 90% from this government of India. State has got 10%. That's how we run the mission.
But not in this program.
But in this program, it's totally in kind.
In kind. Okay.
In others component, we get in cash. For constructions, or carrying on programs, we get in cash also.
Okay.
Obliged.
Yes.
For hearing, item number 12.
Yes, ma'am, what is this matter about?
Lordships, this petition is covering one of the component program that is launched through the Angawadi Center. So we are covering, this petition is covering the supplementary nutrition portion, Lordships, where the state government is mandated to give ration, take-home ration or whole cooked meal to children below 6 years and pregnant and breastfeeding mothers through the Angawadi centers. Or in case if they are unable to do that, then they are supposed to furnish food security allowance as per as been mandated under the National Food Security Act. Lordship. So
Food security allowances in terms of cash.
yes, Lordship. In case of failure to provide cooked meal or take-home ration, Lordship. So, Lordship,
Yes, please.
on the last occasion, that is right order, where the matter was heard on 26 April 2023, the state respondents number 2 and 4 were directed to file their affidavit, but then they said that they are not filing. So,
20? Which order?
2604 2023.
26/04/2023. (26/04)
Of 2023.
2000. Okay.
The court was also kind enough to intervene, and then from the inception of filing this petition, Lordship, series of instruction was also given to the Department of Social Welfare Department, Lordship. However, till date, they have not filed affidavit in response to the main petition. So, but I'm told that they will not be filing. So, Lordship, this is why this matter is listed for hearing.
Why the state is not filing affidavit? Justify.
I'm for respondent number 2 and 4. The 2 and 4 is respondent, chief secretary, and respondent number 4 is the director of food and civil supply. So logically, the lawsuit mechanically comes to the prayer portion.
What is that?
The prayer portion, which is to do only with the social welfare department, and that is not the instant petition. The instant PL petition pertains for providing food and security allowance and other nutritional activities.
Who is the chief secretary? Who is the chief secretary in the hierarchy of?
However, the implementing department is a certain and they will be
Is it not the duty of the chief secretary to actually supervise all this? Whether the department is correctly functioning or not?
That is, yes. But however, here the prayer of the petitioner is to do with the.
You are taking the entire case within a very narrow ambit, Mr. V. Jimomi. Something has not been given to the public which the government is supposed to. Now you actually just to absolve yourself, you try to shift the whole burden on the department. What is that? As the chief secretary, you are also equally liable, responsible for the welfare of the people. Chief secretary does not mean that he is holding such a high post that he is actually not He has nothing to do with the welfare of the people. It's not like that.
Not that problem. However, if you come to the prayer portion, prayer of the instant petition portion, this is only to do with the providing of the supplementary nutrition portion. So, portion if I remember that.
This is the order which we here it says that as are not further, they are also to further
Respondent to and fro, no?
But they have to further. But here in this court order 14.6, it says that they are not entitled. They are not. So 14.6, it will be order 14.6.
Moreover, also,
Have you furnished the copy 14/6/2023 to the Chief Secretary? Have you furnished this copy to the Chief Secretary? Kindly let me see the letter. Respondent number one, madam, not a necessary party or what? Respondent number one.
Yes, Lordship, because they are a funding agency.
So
Lordship.
where is respondent number one? Who was representing respondent number one? Madam, have you issued notice to respondent number one?
Lordship, I believe we have taken steps because this petition was filed in the year 2020, Lordships.
No, it's not a question of filing in the year 2020. It's a question whether you have served notice because I think not even in one of the orders passed by this court.
Yes, Lordship.
We are seeing anyone representing respondent number one. And respondent number one is one of the necessary parties.
Lordship, yes.
Oh.
Lordship, in that part, let me clarify from the minutes CGCs. There are two CGCs. And the first is called again.
Let me just see whether anyone has represented them at any point of time. Our CGCs are like eels, very slippery, very difficult to catch them. Mr. Yangarwati, see the order dated 9/2/2021. See, Mr. Yangarwati, learned CGC appears on behalf of Union of India. Then when we call them suddenly, they will come with an excuse saying that they are not authorized to represent the Special Welfare Department. That is how things are happening. 21. None appears for the Union of India, respondent number one. The second order 9/2/2021. Yangawati. Yes, Mr. Yangawati. You are very slippery.
I was not aware this is my case.
Aha. You have accepted, you have represented respondent number 1, and you are the main respondent. You are still yet to file affidavit.
Worship, I don't remember forwarding the case, this matter to the Ministry of Women and Child.
To take steps. Take steps.
I think they have not given me an extra copy, that's why I have not taken steps.
When you are forgetting the case, how can you remember?
Requires. Furnish
Because
extra
Worship,
copies.
only after they give the publish the provide extra copy that I take steps.
No, see, Mr. Yangawati, that should not be your excuse because on 9/2/2021, you have appeared for the Union of India. So once you have appeared, means it is your responsibility to take steps to actually seek for the copies, to send the copies. It is your responsibility. It is not that somebody.
During modern day, they are usually give it.
No, but once you have appeared, once you have actually entered appearance, you should at least ask them to give you the copies. We will not listen to you.
Yes.
So we will not list it for hearing on the next date. We will list it in the admission stage.
Lordships.
But kindly see, this I think these are issues where you have to take some responsible steps. I think we will have to record all the names. Okay, you are baptized now in this case. So, I had MS Nito Koza, the learned counsel for the petitioner, Mr. Yangawati, the learned CGC for the respondent number 1, Mr. V. Jimomi, the learned government advocate for the respondent number 2 and 4, and Ms. Apila, the learned counsel for the respondent number 3. Okay. Stop. The learned counsel for the petitioner shall furnish the copy of the writ petition to the learned CGC in the course of the day, ma'am?
Lordship, yes, we can do that.
In the course of the day. And the respondent number 1 shall file the affidavit in opposition within a period of 3 weeks, 4 weeks from today. Stop. List the case in the admission column. Mr. Yamawati, please see that actually the matters are expedited because this is 2020 matter. Okay, and it depends on you, on what you have done. Okay, for the people.
If I get a copy today, I will.
Yes, please. You finished 2 copies.
Lordship.
One should always be with him.
Yes, Lordship.
Okay, and the other one you send it to the department. Okay. Over.
Consider